Your last name is pronounced Magoo?
Yes, ma'am.
And generally speaking, I appoint the public defender's office to represent at least at the arraignment stage, but I was informed that you didn't want to speak with the public defender, so are you intending to represent yourself for the arraignment?
I'm here to figure out what the charges are. What am I being charged with?
Hey, Magoo. Ready for preliminary examination, or at least to deal with his motions? What are we doing?
Yeah, would the court be so kind as to make the self-representation inquiry? And
Yes.
perhaps we could look at the motion first.
Mr. Magoo, you are here before the court. You're set today for a preliminary examination. You're here before the court on the charge of resisting and obstructing a police officer. That's a felony, punishable by up to 2 years incarceration, $2,000 fine plus court costs. You appear here unrepresented as you have in the past, and the court has given you the admonishment regarding self-representation. You're going to represent yourself?
Yes, Your Honor.
Okay, what are we doing?
To begin, I'd like to just announce a brief summary of the incident that happened.
Pardon?
The incident on October 11th, the reason why I'm here, I would just like to announce a brief summary of what happened.
And that's going to get us where?
Well, I did file a motion a couple weeks ago for discovery. I do have a copy of each.
Yeah, no, I saw it. Did you get the discovery?
I did not, but I don't think I properly served it on the prosecutor. So I'm here to do that today. I did serve it with the courts. I did file with the courts.
Oh, no, I saw it. So what do you want me to do with your case today?
Well, I a few things. I want my bond conditions lifted. I want a discovery. I don't know exactly what the procedures here is. You know that wrongly.
Yeah, I know, because as you're talking and as everything went through, I could tell you didn't know.
Yeah, sorry. But I'm trying my best to do things right. But I just
Okay, you haven't started out well.
sorry. I'm here because I'm told to be here today, Your Honor. That's all.
I know.
So what I want to do
kind of goes out in my name. So yes, I know why you're here. Let me ask you this. You want to represent yourself in
Yes.
this?
Yes, Your Honor.
You don't want help?
No.
Okay. So I'm going to do this. I'm going to apprise you, if you wish to represent yourself, you're constitutionally entitled to do that. I will apprise you that you are before the court on the charge of resisting and obstructing a police officer. You understand that charge?
I do.
All right. That is a felony or a high court misdemeanor. It is punishable by up to 2 years incarceration, a $2,000 fine plus court costs. You understand that?
I do.
All right. You also understand, sir, that there can be great peril in representing yourself.
I understand.
You understand also that at this proceeding and any other further proceeding, that the court is going to hold you to the same standard the court would hold anybody else to. And the court will not play favorites. The court will not help you out. The court will not be assisting you. You understand that, sir?
I do.
All right. If at any time you wish to be represented by an attorney, and if you cannot afford to hire an attorney, but if you wish to be represented by an attorney, the court will afford you that opportunity to be represented. You understand that?
That process is throughout the whole discovery and trial.
Pardon?
I can be assisted with if I can.
If you
later
request an attorney represent you in this matter, that the court will at that point, if you cannot afford to hire one, the court will make sure that you have one. If you wish to get your own attorney, the court will afford you that opportunity to do that. You understand that?
I do.
So what do we wish to do today?
I would like to first file a request for suppression of this evidence until full
Suppression of what evidence?
of body cams, squad footage.
On what basis would you be doing that?
Miranda versus Arizona.
Which says what?
That I was not read my rights prior to being detained. I have not. No.
And you asked them, how do I get discovery?
No, I will be doing
You
that.
ask anybody how to get discovery.
I asked a couple of the clerks, but they can't, give too much legal advice. So I'm trying to take as much responsibility for this as I can.
Okay, well, I'm gonna, at this point, deny that motion because there hasn't even been a request for discovery. If you don't get something, then you bring a motion for discovery.
Okay.
Next thing you want to do.
Discontinue all hearings until there's substantial evidence on file.
Okay, that doesn't happen that way. I don't know what discontinue all hearings mean.
I don't know either, Your Honor. I'm just representing myself over here.
This is going to be a long process if you just are throwing stuff out there.
I tried to prepare my best for this. I'm really
Okay, this was your best?
I'm
Then
not.
you may want to consider getting an attorney, but I'm going to let you go because you have a constitutional right to do it. But this is going to be a long, arduous process if we're going to go at this rate.
What does the prosecution expect next in this case?
Pardon? What do you mean?
You're asking me for what I want out of this case and what I expect.
I'm asking you, what do you want to do today?
I want to go home and have all charges lifted.
That's not going to happen.
Okay, so
I mean,
what do I got to
going
do
home
to
is
get?
an option, but the charges aren't going anywhere.
I understand, and that's the end goal of where I want to be one day, acquitted of all charges.
Yeah, I don't mean to interrupt, but I am from the public defender's office. I'd be happy if the court wanted to pass us to talk with this gentleman.
He says he wants to represent himself, and if he wants to talk to you, then yeah, I mean, I know, Mr. Getty, and I appreciate it, but what do you want to do, sir?
I'm not sure what you're asking me. What are my options, sir? Your Honor.
All right.
What do I want to do?
What do you want the court to do?
I want the court to find on what grounds throughout the discovery process that I'm guilty of these crimes.
Okay, sir, it doesn't, you seem to want this process to work away. It doesn't.
Maybe that's a disadvantage of being pro se, Your Honor.
Yes, there are huge disadvantages because I think you know what you're doing, but you don't.
This right here is the turning point, and it's brutal. The judge isn't just disagreeing, he's flat out calling out the defendant's lack of understanding of basic legal procedure. In court, representing yourself isn't just risky, it requires a solid grasp of rules, evidence, and process. What we're seeing instead is someone throwing around legal phrases without structure or meaning, and that's dangerous. The judge even hints at competency concerns, which is a serious legal issue. Let me ask you, should courts allow someone to continue like this, or step in sooner to prevent things from getting worse?
It's become readily clear to me. You have no idea what you're doing.
Right.
And so I'm going to ask you, and it's going to cause some difficulty for you. So I'm going to ask you again, do you wish to be represented by an attorney?
I do not.
Okay. Motion denied. You know something, sir? Just because you use what seem to be legal words and try to place them into a sentence doesn't mean that it makes sense.
I understand that, Your Honor.
No, I don't think you do. I think you were just placing words in sentences, thinking that because what you're asking for makes no sense. And if you think it does make sense, then maybe this court needs to send you for a competency. And I'm not saying that jokingly. This doesn't make any sense. I'll grant your adjournment. Next time you'll need to fill out a sheet to do it, but I'm not going to waste the time today to do it because.
Thank you, Your Honor.
In your honor, for the record, I put the email address the defendant should contact for discovery on this post-it note, which I'm going to place here, and he can pick up. He's indicated he doesn't want to communicate with me about this case.
He doesn't want?
Oh, at
He
that
doesn't want to
moment.
communicate with me about his case earlier, so I'm not going to speak with him today about this case. So I've given him the post-it note to get discovery.
Oh, yeah, that's a good way to get this going. All right. Probable cause conference. Let me at least have some turkey before I have to deal with this again. December. court is clear, does believe that you do indeed understand the charges as well as the maximum penalties. There are certain dangers in representing yourself, and it can be fraught with some difficulty. However, I would indicate to you that you are absolutely constitutionally entitled to represent yourself if you so choose to do so. I will treat you no better, no worse than a licensed practicing attorney, but that also means that I will not show any favoritism. You are to also understand and know and operate by the Michigan Rules of Evidence and Michigan Rules of Criminal Procedure. If at any time during the course of these proceedings, you decide that you wish to be represented by counsel, cannot afford to hire counsel, then an attorney will be provided to you. So that we don't get into a thing, I am going to assume, unless you say something different, that you understood everything that I just said. Hearing nothing different, what are we doing? Sir, do you wish to be represented by counsel? I guess I'll ask that.
I do not.
All right.
Thank you.
What are we doing?
I think defendant has a pending motion.
Yes, go ahead with your motion, sir.
Still waiting, motion to compel the officers. I thought I'd be here today to speak with them on the record. It's what I've been requesting since my arraignment.
I know, but you requested a deposition. That wasn't going to happen. So what is it you're looking for the court to do?
Your Honor, I'd like to speak with the officers on the record. I've been requesting this since I'd like to.
So do you want to have your preliminary examination? Is that what you want to have?
Yes, Your Honor.
All right.
Sorry.
Is there a response from the people regarding that?
Your Honor, that is one part of the motion.
I know.
And so as to that part, people will be requesting an adjournment of the preliminary examination today as the officers are not here. But as to the other pieces of this, that there are many more things. I did file a written response, which I'm happy to rely on, unless the court has specific inquiries placed to make of that is not sufficiently flushed out.
All right. Sir, what about the other part to your motion?
Is that in regards to waiving my bond conditions? Which part are you referencing, sir?
It's your motion. You go ahead. I will rule on that part. What other part of your motion do you want the court to deal with?
To waive all bond conditions, leaving the state, and I'd like to get the officers on record. That's really what I've been wanting to do. I thought that's what I was here today. I was prepared to do, Your Honor.
Do you have all of the discovery?
I was just submitted an audio file this morning, Your Honor, from the prosecutor. However, it must be corrupt or something. It's not going through. I'm trying to get a valid copy from her. But other than that, I believe I do.
That's correct, Your Honor. We did send over an audio file this morning, and I did see the defendant reply that he was having trouble playing it on both his laptop and on his phone. I will note it. I'm just seeing today, it looks like the defendant may have a MacBook, and I know that those can have a little bit more of a difficult time with some of the audio files that come from my office. So that may be something that, I don't know that the file is corrupt. I think there's just an issue playing the audio.
Got it. And this is a audio of,
I believe it's the 911 call that brought the officers to the scene.
Now calling case number 25S00289. This is the state of Michigan versus Daniel Ryan Magoo. Can you please state your name for the record?
I'm trying to figure out what the charge is.
Yes, that is the purpose of the hearing today. So as
Who's
part of
the complaining victim?
the proceedings, can I have you please state your name for the record?
My name is Daniel Magoo,
Okay.
and I am
thank
not
you.
a surety of the state. I'm not a ward of the state.
Okay.
Can I ask what the charges are?
Yes, I am getting there. Please give me a moment. So what we are here for today is an arraignment. The purpose of an arraignment is to inform you what you are being charged with and to make sure that you understand the charges. I am not going to be asking if you agree with the charges. I am not even going to be asking if you understand why you are being charged with them. The purpose is to make sure that you understand what the charges mean and that you understand what the potential maximum penalties are. So what I have here is a misdemeanor complaint that charges that on or about or between the dates of February 15th, 2025 and June 23rd, 2025, you did maliciously use a service provided by a telecommunications service provider with the intent to terrorize, frighten, intimidate, threaten, harass, molest, annoy, or disturb the peace and quiet of an individual with whom you have a child in common by using any vulgar, indecent, obscene, or offensive language, or suggesting any lewd or lascivious act in the course of a conversation or message through the use of a telecommunications service or device. This is otherwise known as malicious use of a telecommunications service. Do you understand what the charge means?
I do not understand that. I do not understand malicious use
Let
of a
me
telephone
rephrase.
service.
Do you comprehend that what I am saying is that you allegedly maliciously used a telecommunications service device that would generally be a cell phone? I suppose it could also be a computer or something else
No, that
you
didn't
could
happen.
use. Okay. And again,
February,
as I
what were the
stated,
dates? What dates?
between February 15th and June 23rd
Of this
of
year?
this year. Yes. Okay. Now, as I stated at the beginning, I'm not asking you if you agree with the charges. I'm not asking you if you understand why you are being charged with them. What I want to know, basically, is do you know what the words coming out of my mouth mean?
No.
Okay. So the way that this is going to work is this. If I am not able to arraign you on the charges because I can't tell if you understand what I am saying, then the next thing that happens is that you get referred for a competency evaluation. At this point, I do not know how long that will take, and that means that you will stay where you are until we are able to either arraign you or you are determined to be incompetent.
So I don't have, I'm not like I said before, I'm not a surety. I'm not a ward. I'm actually a protected individual and I did no crime. There has been no body of a crime, no corpus delicti. I have committed no crime at all.
Mr. Magoo. If I cannot determine whether or not you can understand what you're being charged with, then I cannot arraign you.
Okay.
So,
If there is not a body of a crime, if I have not harmed anybody, then you can't arraign me. It's corpus delicti. It can't happen. And if you do try to enter in a plea of competency or I don't know what is that? What you're gonna hold me here hostage until what? A body of a crime happens? When is the crime gonna happen?
okay. So, Mr. Magoo, we will not be proceeding today with the arraignment. You are free to go to the door and tell the jail that you are finished. Thank you.
At this point, the case takes a serious turn. The judge can't even proceed with the arraignment, not because of disagreement, but because the defendant clearly doesn't understand the charges. Legally, that's critical. If a defendant cannot comprehend the accusations, the court is required to pause everything and consider a competency evaluation. What started as a routine hearing has now escalated into a question of mental fitness to stand trial. And in the end, the court halts the process entirely. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.